Aurangzeb. She is currently the Balochistan member of the National Commission for Human Rights. Professor Farkhanda was the senior consultant human rights education at the NCHR. She is the manager of Legislative Watch program at Aurat Foundation and has served as director Aurat Foundation. Our second panelist is the esteemed Miss Valerie Khan. Miss Valerie is a gender equality and social initiative, child protection and justice with children expert with 26 years of professional experience in human rights-based development. She specializes in evidence-based legal and policy reform, capacity building engineering, program management and monitoring evaluation, accountability and learning, rule of law and cross-cultural communication. She has extensive experience in comprehensive and tailor-made protection, rehabilitation, and reintegration processes of women and children vulnerable either vulnerable or survivors of violence. Joining us on Zoom is Ms. Sahar Bandeyal. Ms. Bandeyal is an advocate of the higher courts. Sahar has a keen interest in gender and law and legislative drafting. She co-authored the anti-rape bill, which was passed into law as the Criminal Law Amendment Offences Relating to Rape Act in 2016, and the Punjab Maternity Benefits Amendment Bill introduced before the Punjab Assembly in 2019. She has been regularly writing on the subject of women's rights in various daily publications. And moderating this panel is Ms. Zoha Shahid, who is joining us again today. Ms. Zoha is the Senior Research Associate at RSIL.
Hello, everyone, and thank you to all our panelists for joining us on this very important and hopefully interesting conversation today. But before I start with the panel itself and the questions, I would like to set the stage a little bit. We're talking about gender justice and child rights here. According to the Global Gender Gap Index report of 2022, Pakistan ranks 145 out of 146 countries. When we talk about the Rule of Law Index, which is published by the World Justice Project, Pakistan ranks 130 out of 139 countries. So, of course, this reflects dismal realities that exist within this general thematic area of gender justice and child rights. But that is not to say that progress has not been attained in Pakistan. We have seen progress in terms of newer legislation, particularly related to the rights of women as well, such as the Anti-Rape Investigation and Trial Ordinance. We have seen improvement in our policies as well, such as the introduction of the National Gender Policy Framework of 2022. And within child rights as well, we've seen the introduction of the Juvenile Justice Act 2018, the Child Marriage Restraint Act 2019, and the Zainab Alert Response and Recovery Act 2019. So across this background and within this context, my first question is not going to be about the challenges that exist. We know that there are a plethora of challenges that exist within these areas. But what I want to talk about is the role of national human rights institutions. We've seen in the past that national human rights institutions internationally have been able to leverage their roles and their mandates to sort of bring change around in a society. My first question is for Ms. Farkhanda, of course. Madam, what do you think are ways in which national human rights institutions, specifically maybe the National Commission on Human Rights, can work towards the better protection of women's rights in Pakistan?
With the larger mandate besides women's rights, what I suppose is that the National Commission for Human Rights can create an environment that can be conducive for all aspects of human rights, not only women's rights, child rights, transgender rights, and then all the rights of the marginalized society and the sections that live within us. If you speak about the justice system, the gender justice system, I would say that why we lack so much in our international indexes that you've just mentioned, there are several aspects that need to be considered. We have lots of laws that we talk about, and sometimes we are also boasting about them when we are at the international level and talking to international bodies, But the fact remains that all these laws that we have, we have 9 laws that need to be very proactively followed. Now, what happens to these laws? They were there, and then all of a, all the machinery of the state does not know about them. There had to be a tripartite action, according to me, which could have made it more accessible for people, which it is not at present. All pro-women laws. The only law that I saw was somewhere implemented somewhere around was harassment at workplace. But having said that, the environment in which our office work is carried, or the way the work environment that we have around, does not permit an employee to talk about harassment, because then the concerns of the organization are there to suppress those voices which would be raised. Otherwise, there were the lots of laws that we otherwise have. See, when you are following an international convention, for example, following CEDAW, we had these pro-women laws, but laws are there, their implementation is missing. Now, the tripartite action that I was talking about is that when these laws were promulgated, when they were there, there should have been a very, very enthusiastically carried out campaign of introducing these laws to the general public. Because if the laws exist and people are not aware about them, how would the justice system work? Secondly, uh, uh, the lawyers who are supposed to practice and carry forward the advancement of these laws are unaware about how these laws are and what these laws are, what are they. And thirdly, the prosecutors who were there, and fourthly, the judiciary who had to see that they were being implemented while their judgments were being carried out. Now, as a personal experience, I have witnessed that even conventions are not known to public very enthusiastically. Because once, when I was working as the Director General of Ministry of Human Rights, way back in 2011, the ministry wanted to submit a report of CEDAW, and that CEDAW report had to be from all sectors and from all sections, especially from the legal fraternity. When the letter was written to Islamabad Session Court, the concerns were raised. Since we had put down our numbers, the concern of the session judges was that they need to know what the CEDAW word means on which they are supposed to report. So I, as DG, thought it was my responsibility. I requested them that they may gather a group of people. See, it's what does the Judicial Academy, what role does the Judicial Academy play? It's supposed to take up each of these legislations, dissect it, simplify it, communicate it to the lawyers, to the people responsible for the dispense of justice, and then to the general public. Now, let's see, we have a very low literacy rate, for example, and yet this low literacy rate does not restrict our effort to make people aware. When you spread things by word of mouth through small interventions on your electronic media, and maybe some small pamphlets distributed with newspapers in your print media, information would reach. But the resource required for all these efforts is usually quoted as an excuse for non-execution of all these elements. So the justice system, when it has to be carried out, let me bring up a very, very crucial, important issue to your knowledge in the background of Balochistan. Since we are working for the juvenile justice system, when I visited the juvenile jail, I found there were young boys of the age of 10. Sometimes even there was an 11-year-old boy, and all that they had done was that they had stolen probably some cheap mobile, not an expensive one. And they were lingering there, languishing in the jail because of non-availability of any legal support, non-availability of the little fine that they had to pay. And then, secondly, our juvenile system need to be reformatory rather than punitive. But what we see as watchdog body, the jail authorities are not performing according to the standards even set by our own country, according to our constitution. See, if there's a little, they can approach philanthropists. The effort needs to be expanded, telling people that this is a minor and has committed a mistake. There has to be some reformatory. Now, when children are free all day long, and when they are there with elder boys like 18 or 17 or 16, what do they learn? They learn acts of practices of more criminal actions and perhaps so. So the reformatory part, the justice system that we are talking about has to be considered very, very seriously. Seriously because we do have laws. We are probably the most largely legislated country, but the implementation of all those laws does not exist. And unless and until the simplest, most layman knows about these laws, they cannot be dispensed. Justice cannot be dispensed.
Right. Thank you so much. And of course, that highlights very important points, and one that I would like to talk about with Valerie as well, which is on awareness that you can create for international conventions. These conventions provide standards that are essential for human rights, and they set this standard that states are to follow as well. So when we talk about juvenile justice, can you shed some light on the international standards under the Convention on the Rights of the Child, specifically with regards to the criminal justice system?
All right. So in the United Nations Convention on the Rights of the Child, there are two specific articles. I would say that the moment you talk about the child, you need to make sure that you abide by all standards defined into the UNCRC per se, and all other conventions that somehow talk about child justice, such as the ICCPR or even the UNCAT. But if we look at the UNCRC, Article 37 and Article 40 really specifically address the issue of children in conflict with the law. I think what is important to understand is that we first have a framework which talks about justice with children, which means that the overall international legal framework is cognizant and enshrines in a legally binding framework the fact that any child who is facing any human rights violation should have a fair, affordable, and transparent, confidential, but safe access to redressal mechanism to address those human rights violations. That means that we can talk about children in conflict with the law, as well as children in contact with the law, which means victim or children who may have witnessed a crime and who may be called upon testifying, basically. The reason why I'm saying that is because when we talk with child justice, the General Comment 24 of the UNCRC, which replaces General Comment 10, which is updated and takes into consideration, I would say, a certain legal maturity, because law is something which evolves, but also scientific elements, especially neurosciences, to inform how we need to address children in conflict with the law, was included into that perception. And so the guideline of the General Comment 24 basically reaffirm and remind all actors of the justice system, which we start from a pre-trial, trial, and post-trial definition of the justice system, that 4 fundamental principles need to be followed whenever dealing with a child in conflict with the law. The first one being the best interest of the child, which we can proudly say is written in black and white in the Juvenile Justice System Act 2018. It's not a small feat. Secondly, the dignity of the child, survival and development, non-discrimination, and the right to be heard. And this is why from the principle of child justice and justice for children, we now have reached to the concept of justice with children. Now, that General Comment 24 was released a bit after that the Juvenile Justice System Act 2018 was enacted in Pakistan, but overall, that law is a good one. I'll highlight how it's constructed, and I'll also point out where it needs to be improved in line with the General Comment 24 and to some extent, recommendation of the latest committee on ICCPR, basically. Yeah. So the Juvenile Justice System Act propose a specific regime to ensure that there is no secondary victimization and that there is trauma-informed justice process for children who are in conflict with the law. Yeah. And that includes, first of all, a huge responsibility on the police to determine the age of the accused following a determined age determination protocol that has been included in the law, which also includes the social and the possibility, when we talk about restorative justice, of not necessarily go to court and rather envisage a more restorative approach, which is called diversion. And so concretely speaking, when it is a minor offense, you can propose, instead of sending the child to court, and based on the social investigation reports, think, okay, it's just a mobile that has been stolen. Maybe that child can, I don't know, present an apology, give the mobile back, this kind of thing, and not go to court. If you really, so that's the diversion thing, and to that effect, the law entails that juvenile justice committees had to be established at district level. Another important aspect is that any child accused at the time of arrest needs to be informed about why that child has been arrested. The parents, the guardian needs to be reached out, legal aid needs to be provided, and most importantly, no child accused can be kept in the custody of police. To keep the child, there is a need to establish, a legal obligation, to establish observation homes. As far as the court is concerned, we need also, the law entails that the juvenile court is a specific space designed in a child-conducive manner. We also have a bail regime which favors, the fact of not sending the child under trial in detention as much as possible. You have minor, major, and heinous offense, and also, importantly, no child is supposed to be in jail. So when I hear expressions such as jail juvenile, the words in itself is a violation of that law. The juveniles in Pakistan are not supposed to be in jail. They're supposed to be in rehabilitation centers. And in addition to this, you also have, an approach to that rehabilitation that is supposed to help the child really come back to the society in a productive manner. Now, the problem is that so in the context of Pakistan, we find ourselves into a very strange situation. We've had historical, unprecedented results, positive results, and momentum to actually boost what I call child justice. That's important. I do not like to use the word juvenile justice because juvenile in itself is already a stigma. So I think there is a need to change the nomenclature. And also, importantly, apart from the Juvenile Justice System Act in 2016, there were two amendments in the PPC, Section 83 and 82, where basically the criminal age for juvenile was also increased to minimum 10. And then, as per the JJSA, as per again the other section of the PPC, from 10 to 14 years of age, it's the judge who's going to assess whether that child has the maturity to be, held criminally responsible or not. Now, the problem that we're having with the JJSA, as what I have described to you, is that the criminal minimum age in Pakistan is too low. as per the recommendation of the General Comment 24, it should be minimum 14. And that kind of margin from 10 to 14 to determine the minimum criminal responsibility should not be there if I follow the guidelines of the General Comment 24. The other problem is that, also very importantly, no juvenile in Pakistan as per law can be executed. All right? It's absolutely illegal. However, the General Comment 24 also insists on the fact that apart from execution, harsh punishment, lifetime imprisonment, and that's also mentioned in the UNCRC, should not be used for juveniles. So when you look at the legislation, just that the anti-rape law, for example, and I have been helping to contribute to that drafting as well, so I am part of the guilty ones who need to do better. Okay, I'm not targeting anyone. That is a problem. It's not aligned with the international safeguards of the juveniles. When I talked about it to the previous Ministry of Law and Justice, they were willing to consider it. I'm hopeful that Al Saib would also be willing to consider an evolution. So right now in Pakistan, we've had piloted a total of 13 child courts, which had double jurisdiction. We've had in collaboration with the National Judicial Policing Making Committee of the Supreme Court of Pakistan, conducted child court performance for those juveniles. Unfortunately, in KP, there has been a decision from the High Court of Peshawar, which has taken away the jurisdiction of the juvenile accused from those pilot child courts. It's not only for the victim, it's very unfortunate. But if I look at the child court assessment of those 13 pilot child courts, which were ensuring a trained judicial team, we need to acknowledge the fact that hundreds of judges, hundreds of lawyers, hundreds of police officers have been trained on juvenile justice. When you look at that around, it's something we need to ensure. The feedback is the following. At least 90% of the juvenile accused were saying, we have been treated like human beings, we were respected, the judge was fair, and we're really thankful. 90% of the police officers were telling you, we feel human again. Now we feel we are contributing to something. The judges sitting in those juvenile courts, the majority of them were saying, now I feel I can look myself in the mirror. I'm really contributing to something different. As far as the juvenile justice committees are concerned, several have been nominated, very few have been established, and when they have, very often they are not operational. From 2019 to 2021, we have identified 4 cases of diversion that were enforced in Peshawar. So I would say, to conclude, extraordinary progress, unprecedented and historical will led by a judiciary to actually improve child justice in the country, but, and that's where, I'm going to conclude here, huge and tremendous work remaining to actually enforce this law, set up the observation home, have more probation officers, set up the rehabilitation centers, institutionalize further child justice, and ensure that juvenile justice committees are not only on paper, and develop a diversion program. And for that, it's not only political will, the donors will need to support. The state is giving its contribution. We feel as a civil society that the donors have abandoned us on that critical agenda, and that's not acceptable.
Thank you so much, Valerie, and thank you for conducting this comparative analysis of Pakistan's criminal justice system, specifically with regards to child justice and the international standards that exist. You mentioned access to remedy, which is, of course, very important, and you mentioned the progress that Pakistan has now undergone. And that brings me to my question for Sahar. When we're talking about gender justice and child rights, of course, the Sadaf Aziz judgment cannot be ignored. So, Sahar, my question to you is, before we talk about the judgment itself, can you shed light upon some of the challenges that you faced when you were dealing with a gender-based public interest litigation?
Thank you, Zoha. I think for the Sadaf Aziz judgment specifically, or the case specifically, I think the stage was to some extent already set for putting up a good arguable case before the court to consider the constitutionality of virginity testing or two-finger test. The Salman Akram Raja case had already been decided by the Supreme Court in 2013, and thereafter there was the 2016 criminal law amendment to the PPC, CRPC, and the Kanun-e-Shahadat order. So we had those sort of developments in place before we approached the Lahore High Court. That being said, what I found particularly challenging in dealing with a public interest case pertaining to gender justice and gender rights was the fact that invariably we were questioning very entrenched sort of stereotypes, biases regarding women's morality, expected sort of type of behavior, questions on what women's sexuality means, what does it mean if a woman is sexually active, and how then is the law to treat such a woman in terms of the protection it provides. The exchanges that we had in court with the bench and with the respondents, I would say particularly from the Office of the Surgeon Medical General, were very interesting, because the conversation was centering around why virginity is important to determine whether a woman can be raped or not, or whether rape occurred or not, or what is the significance of a hymen or the condition of the vaginal canal or the elasticity of the vaginal canal in order to determine rape. We have presented a lot of sort of international material and consensus on the position that two-finger testing, virginity testing, and the elasticity of the vaginal canal or the presence or absence of the hymen are not relevant when it comes to determining the question of whether rape occurred or not. However, the response from the Surgeon General Office was interesting. They were not willing to take that position. They were not willing to accept that position. For them, the virginity was critical. The question of virginity was critical to the question of whether or not rape occurred. In that way, the sexual history of the female victim was essential to be determined in a medical legal examination. And behind that insistence was obviously the understanding or the entrenched belief or stereotype that a woman with sexual history is someone who is more likely to consent, and therefore is less likely to be raped. So the category of rapeable, unrapeable woman was very entrenched in sort of the psyche and understanding of the officers who were representing the office of the Surgeon Medical General, Surgeon General Medical Legal. So essentially, we were questioning those kind of stereotypes in our litigation before the High Court, and this sort of line of or this sort of these presumptions, these stereotypes were actually pretty much articulated in earlier judgments of the superior courts of Pakistan. So they were reflected in judges' thinking as well. So just to sum up, that from this experience, the litigants involved, the lawyers involved realized, and I learned personally, that when it comes to questions of gender rights or gender justice, these very assumptions, which are extremely entrenched in our thinking amongst women judges or male judges, need to be questioned. And the keenest, finest legal minds may not be able to, or it's difficult for them to sort of step away from these stereotypes at times. So for me, that was challenging, but we were lucky to have a bench which was willing to look at this issue from a different perspective.
Yeah, thank you so much, Sahar. Of course, these challenges really highlight what we're dealing with. When we talk about gender, we're not talking about women only. And when we talk about generally this movement, of course, it needs to be cross-sectional. So, Ms. Farkhanda, my next question for you is going to be, how do we bring transgender rights into this conversation, and how do we ensure protection of transgender rights? Because, of course, this without cross-sectionality, this movement, protection of human rights, it cannot be achieved. So what are your thoughts?
Very, very important aspect that needs to be taken into consideration when talking about transgender rights is that there's a lobby, I'm talking about the present times, distorting the entire legal framework that was set to facilitate them. And in the light of that, I think protection mechanism requires their rehabilitation, not as transgender, but as a human being. Then there should be some emancipation process to be led by the civil society and the state in partnership. And thirdly, there has to be some sort of commitment on part of the sections of society into which they move, that their dignity and their right to honorable living is absolute. What do these two rights demand? The demand of these two rights is that they should be considered a normal human being, though this has never been the trend of a society. And then a very, very important thing that we should keep in mind is that their present form of gender is none of their fault. They've been created by nature, and in the first place, it should not have been the parents who would take them secretly in midnight and throw them into some guru's lap. The responsibility lies with the parents foremost, because the state has the responsibility, but the prime responsibility is of parents. They need to keep their children with such gender neutral gender into their own custody and raise them as normal children. Secondly, when it comes to the state, since lots of legislation supports them, and in spite of all that's going on around us, I'm a very optimist person and don't think we need to pay any heed to all those things that are going around us regarding the transgender community. What we need to do is to provide them opportunities of reforming their present form. For example, when people are out begging, which is the only source previously they had, except that we do have few exceptions who have been excelling academically and teaching in Quaid-e-Azam University or others becoming doctors and all, because they'd been patronized by their parents. So we need to see what are their aptitude, because I, in Balochistan office, hold a meeting of transgender community across all over every alternate month, and the concerns that we address as a commission is that they need to be brought into mainstream of life. They are a marginalized section, the most marginalized I would call, and they need to be brought into a mainstream of living social system. To do that, I practiced talking to them. Okay, for instance, if you had an opportunity to build some capacity, what would you like to do? And all of them had plans in their mind. See, in spite of all the drawbacks, they had a plan in their mind. And there was a student who is now studying in the Balochistan University. Desire was that I've done my graduation and I can't find any opportunity. And I feel shy to see that people would be looking at me with the humiliation that usually we face. There was another female who said that she is so well trained in producing handicrafts, but she doesn't have the resource to do. So I think we should not always look at the state, what can the state do? Each one of us, in our little capacity that we can, we should support small initiatives. Coincidentally, the Social Welfare Department had declared a training program. So 4 people were put into those classes for dressmaking, for a saloon, and for the beauty parlor work that they do. And the fourth one said she's interested in learning computers. You see, each human individual has some skill inbuilt within them, and that skill needs to be brought out. So the handicraft person is making handicraft. We connected with the technical training school that we have over there, the training center for women, and they display their goods and they are sold and they make their life. See, now bringing them into track of mainstream cannot be done overnight. It has to be over a span of time. We need a plan of action for that. And that plan of action needs to be followed religiously so that we bring them into measure. For their protection presently, what is the most challenging thing for them? They can't find a place to live. Wherever they live, people make life difficult for them. Assaulting them is one of the most prominent things that happens all over. So we need to provide them some place of shelter where they can spend a life of honor. Even when they become capacitated with some skill, they still need protection because that stigma which we, the society, has created for them does not, they can't get rid of it so easily. It may take centuries to make them grow the way we grew up in our childhoods. So that protection has to be there. The social welfare department tried to establish a protection center, but they failed. In, I'm talking about in the perspective of Balochistan. So we need to have shelter homes for them with all respectable resources delegated by the partnership of civil society and the government, and it needs to be considered very seriously that they should be brought into mainstream of life through their rehabilitation, emancipation, and then provide them the required protection. Most of all, it's their dignity which needs to be retained now. It's the dignity that needs to be infused into the minds of public. There should be no stigma attached to their presence because why should they be stigmatized? Right. See, it's a creation of nature. If it's a deformed child, we would not throw the child away. But if it's a transgender, parents would prefer to get rid of the child. So protection, rehabilitation with small initiatives. See, very small initiatives can make people feel dignified
Right.
and well treated with all their rights to be preserved.
Thank you. Thank you, ma'am, Farkhanda, of course, for that comment on the protection of transgender rights. But of course, I would like to highlight the role of the state here because the state is the foremost protector of human rights. And when we talk about human rights, that means all human beings and not just human beings that we think to be human beings. But that brings me back to Sahar for the second round of questions. Sahar, I am a huge proponent of the fact that when we talk about the protection and that the state provides and the role of the state, having women in leadership positions is really important, especially when we're talking about gender justice and child rights. So I want to talk to you about how do you think having more women in the judiciary, especially in higher positions, how would that change this gender justice and child rights fight that we are in right now?
My experience, and I think others who've been in the field will also possibly agree with me, is that there's a general disbelief in the criminal justice system against complaints of violence against women or complaints of sexual violence, domestic violence, etc. And that sort of culture of disbelief exists or starts from the police, and we find it in the lower judiciary as well. I interviewed in additional sessions judge a while back for a project. She was a female judge, and when I asked her about, why is there such a low conviction rate in rape cases, her response was that most of the women who approach the court, who file an FIR rather, they build false cases, that most of the claims are false. And this, I think, culture of disbelief penetrates the system across the board. And having more women in decision making roles within the judiciary, I believe, may help change that culture, may help provide some greater degree of, they may accord greater degree of credibility to the statement made by a victim of sexual or domestic violence. And I also was a part of this conference, which was held earlier this year in Islamabad, actually on the gendered perspective in judicial decision making. There were a bunch of a group of female judges who had gathered from across Pakistan, and the conversation we were having there was how having more women, having more gender balanced judiciary can bring a different perspective into judicial decision making, because each individual comes from a particular background, there's a particular set of experiences and belief systems that they bring into place. Having a woman in a decision making role um, possibly puts her in a position where she is able to understand, possibly in a better way, what a female litigant is suffering, what is actually her grievance.
Yeah.
Now, going back to the Sadaf Aziz judgment, I think for us, having a female judge, a lady judge, adjudicate our case was probably very lucky for us, and for the legal system generally, because that's how the law evolved. Because I think Justice Aisha was able to bring a particular gendered perspective to the decision given by the Lahore High Court. The gendered perspective being what is the particular experience of a woman when she approaches a police station, when she has to undergo medical legal examination and a two-finger test. What is her experience when she is asked certain questions regarding her character and cross examination to disparage her testimony, her character? Those sort of questions were asked by the judge on the bench. And the fact that she was a woman, in my opinion, possibly informed her sensitivity towards those issues. I mean, the judgment concludes and reasons that um, the entire experience of the criminal justice system for a female victim is in fact re-traumatizing, and that there is a need to sensitize that system, for that system to evolve in a way that a woman is treated with more care and with more caution. I believe that this sort of gendered perspective uh, was very important for us and is important when other cases are adjudicated before the courts which deal with women's issues or children's issues, be they family law or law regarding relationships or violence between when people within the home. Um, so, in my opinion, so I think it makes a huge difference having more women in judicial decision making roles. It can help change the narrative, it can help bring in a different perspective, a different understanding. And this is not to say that the gendered perspective is only limited to women, or only women can have that gendered perspective. I think uh, through trainings, through greater exchange of information between individuals, through conversations, the gender perspective can be inculcated in other individuals' thinking as well, so that all those placed at the helm of decision making, judicial decision making, can bring in a gendered, a more informed, a more balanced perspective when it comes to judicial decision making. Maliha Zia is works in Karachi with the Legal Aid Society, and she's done a lot of work on how language in judgments ends up reflecting certain biases of the people who are adjudicating.
Yeah.
That suddenly a child, and I remember this from a presentation I attended where she was presenting. Suddenly, a child who's been a victim of sexual violence, her age, her minor, her young age is effaced from the record, and she's referred to as Musamat. So the sort of heinousness of the crime committed against her disappears because the language is not sensitive enough or does not reflect the heinousness of the crime. And if we are together as members of the legal fraternity, and those especially who are involved in judicial decision making, if we are made aware of the importance of this gendered perspective and how this gendered perspective should be reflected in our language, I am hopeful that more sensitivity will be brought into the system, into our decision making.
Of course, thank you, Sahar, for those very important points. So Sahar mentions care and caution. two very important principles that apply equally to gender justice as they do to child justice as well. So Valerie, of course, I'd like to unpack the Juvenile Justice System Act 2018 with you. Can you take us from the pre-trial, trial, and post-trial stage and sort of talk about where care and caution exist in the act as well?
Okay, only. Yeah, okay, all right. Well, again, care and caution are already enshrined into the four fundamental principles that were enunciated earlier, which is best interest of the child, non-discrimination, um, right to be heard, and dignity, protection, survival, and development. But I think what is important, you talk about women representation. I'm not going off the topic, but when you talk about increasing women's representation in the justice sector, we need to understand that that cannot be limited to the judiciary. Justice sector means you need more women in the police, as well as in the legal fraternity, and indeed in the judiciary. Now, from a child justice perspective, which means children in conflict with the law, I want to go, we never ask ourselves, what do we actually demand care and caution for a child who is in conflict with the law? And the first response is, because we are talking about children, because we are not talking about adults, because they do not have the same agency, because they do not have the same capacity to take that decision, because they are vulnerable. And therefore, you need special measures. It's very much enshrined in our Islamic jurisprudence and in our constitution. And the care and caution that I'm supposed to give to those children in conflict with the law are already present in our Islamic jurisprudence and constitutional framework, and of course, in the international obligation that we have committed to. So if you say, where do I start? Well, let's imagine that someone comes to the police stations and registers an FIR against a child. I would say, first thing is use your common sense. We've had situation of FIR where the accused was 3 months old. So if I am a police officer, and if someone is going to say, I've been attacked by this 3 months old already, I should have an alarm ringing and saying, oh, there is no way I can register such a frivolous FIR. Number one. I repeat, the minimum age of criminal responsibility in Pakistan is 10. It's not enough, but that's better than what it used to be, because before 2016 it was 7. Secondly, the moment I'm supposed to arrest the police, in an ideal world and in total alignment with the JJSA, I could even send a police officer not necessarily in a uniform in order not to scare the child. I arrest the child, all right, which means I immediately inform the parents, arrange and ensure that the child is legally represented. If the parents cannot afford it, I'm supposed to be in contact around the police stations or with the bar, I don't know. I can vouch that I know many police stations who have phone numbers of lawyers that they can call, or civil society organizations that they can call to ensure that that child is going to be represented. And then the first duty of the police is to determine the age of the child. And for that, the law tells any pertinent document. Even if one day I've played a football game when I was 10 years old and I have a certificate, that's good enough. Okay? It doesn't even have to be a CNIC or a birth certificate. The medical ossification test examination can only be conducted if there is absolutely nothing else. All right? I mean, that's what we keep on telling the police and the judges, okay? The medical test is the last tool that you're using. And if you already have official documents attesting the age of the child accused, you don't need a medical test. Okay? And the reason for that is because there is a margin of error for those medical tests between 2 to 3 years, and it's not a reliable test. And that's why it's really put aside as much as possible. So let's say that you have your age, which is determined, the guardians are informed, the child is being legally represented. As a police officer who is very much aware of the JJSA, in an ideal world, I know that I cannot keep the child in custody in my police station. So ideally, again, an observation home has been notified, which is not the case to date, and I will send the child until I take a decision or send the child to the magistrate in an observation home. If there is no observation home, in between, or if by the magistrate I'm not sure, I can also refer the child to a suitable person, which can be a child protection officer, a retired judge, whoever, someone I trust. And then, as a police officer, I can also, with the help of the probation officer, assuming that there is a probation officer who has been notified and who's available and who will answer the phone call, I will ask the probation officer to go for a social investigation report. And that social investigation report is a kind of case assessment to see if that child can be referred for diversion. Again, taking into consideration the kind of offenses. Are we talking about a minor, major, or heinous offense? And then if that, I think that that child can benefit from diversion, if I think that I have a chance to keep the child away from the trial process, which means I increase the chance of that child eventually ending up into detention. Remember, as per General Comment 24 and as per the UNCRC, detention always has to be the last recourse and for the shortest period as possible. That's why you have diversion options and bailout options. So if as a police officer, I think that that child could be benefiting from diversion, that's what I'm going to present to the magistrate. I think there is a minimum, there is a delay of 24 hours, Sharafat Saib, for all this process to be, and if I can't do that in 24 hours, I need to inform the magistrate wise and still abide by those protective measures. Now, in the court, and also while this is happening, as a police officer also, and when I have to present, if I decide, let's say, to present the child to trial, if I think that it's not possible to give diversion, I also need, also very important, sorry, I should not divulge the identity of that child accused. So the kind of show or pictures that you've seen, and again, I'm highlighting the bad example versus the good ones because we have both. You've seen some police officers taking pictures of juvenile accused, posting it on social media and saying, hey, look at the great work I'm doing. I'm arresting the accused, okay? That is absolutely illegal against the law. And we've had police officers at the highest level who've been very active to stop this. In KP, in Peshawar, they have even forbidden taking that officially. So it's not a terrible, always a terrible scenario. You have a lot of good people in the justice sector who are also doing what they can. So let's imagine you go to court from that observation home, and then there, of course, first thing, the magistrate needs to be trained. Okay, that's a big problem we're having. You need that expertise. Child justice and justice with children or gender justice is an expertise, and the world increasingly shifts towards expertise-based justice processes. So they will look at, first of all, what's the age? Is juvenility confirmed? What is the proposition? Is it diversion? If yes, that will be referred to the Juvenile Justice Committee, assuming that that committee has been notified, established, and is operational. And that Justice Committee will, in agreement with the victim and the parents and the child, propose a diversion option. Now, if you go to court, otherwise, because there is no diversion option, the judge needs to ensure, the judicial officer, the presiding officer of that court, needs to ensure that, again, the identity of the child will be preserved, preferably not handcuffed, unless you are absolutely convinced that he's going to fly away and that it's going to be dangerous. Making sure that the language is adequate, have a kind of assessment of the capacity of the child, and also making sure that availing legal representation, the child is not being treated in an offensive manner, in alignment with the Code of Criminal Procedure, and that everything is ensured so that the child may give what you call the best of evidence. So that is about, when we train them, it's a matter of ensuring that forensic communication, which is child sensitive, does occur in the court of justice with the legal representative by the judges, and the presiding officer, the judicial officer, has to ensure that that child is not ill-treated. You also have facilities such as video linkages. If the child doesn't feel well, the trial can be interrupted. There are lots of if you need to ensure that the child understands what is happening. So you may use communication aids, you may use translators. It's very important to use a language that the child can understand. We have an example from UK, for example, where the judge, just before taking his decision, asked the juvenile accused, are you remorseful? Are you feeling remorseful? And the child was absolutely terrified and thought, my God, remorseful must be a terrible thing. And he looked at the judge and he said, no, 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 sir, I'm not. And the judge afterwards, he gave the most severe punishment that was available because of that answer. It's not me saying that. It was a very famous linguist specialist who had presented her thesis in Leiden University in the Netherlands. And she was explaining how not using the level of languages that the child knows is problematic. Especially when you are dealing, let's look at the profile of those juvenile accused. They, in the vast majority, belong to illiterate environment, very vulnerable socioeconomic environment. And so, you need to be more empathetic and help them. Now, the trial will take place according to the age and the fact that it's an offense. A court decision will be taken, and now the child needs to be sent. So whether, hopefully, he will be innocent, and if not, if he didn't avail diversion, he has to be sent to a rehabilitation center. And that's, again, the problem. We do not have rehabilitation center. And frankly speaking, the head of the prisons in Pakistan are all trying their best to try to somehow bring in rehabilitative dimension to the jail environment. It's just simply not compatible with the structure, with the way the staff is being trained. You need a separate, it's a different environment. It's a different approach to justice. It's a restorative approach. And until that is not done, what we need to understand is that not all children abused are going to be abusers, but 99% of the abusers have been abused at some point. By not considering child justice as another segment and another form of early intervention for child protection, we are contributing to creating the next generation of abusers or victims. International research shows that children who were in conflict with the law and who went through the full justice system too often, and children who were abused, definitely, too often have an increased likelihood to become whether abusers or victims. So basically, restorative justice, and I stand by it, is one of the key elements to foster child protection, number one, at an intergenerational level, and also, very importantly, counter gender-based violence and violence against women and girls. Start with the children to stop the cycle of violence against women and girls, to stop the cycle of GBV.
Thank you so much, Valerie, and thank you for this walk across our criminal justice system.
I'm not a lawyer. Yes, I'm not a lawyer, so if I made a mistake, please feel free to correct. Okay, sorry.
No, of course. I would like to now move on to institutionalization, and Sahar, that brings me to my next question to you. I would really like to talk about, we've been talking about implementation, we've been talking about challenges specifically related to implementation. So my question to you is, how should the judiciary, executive, and the legislature, all three institutions, help and ensure in the implementation of the Sadaf Aziz judgment?
So let's start with what exactly the Sadaf Aziz judgment said or held. First, it held that two-finger testing or virginity testing has no probative or evidential value. Second, it held that the past sexual history of a victim was irrelevant to the question of whether she consented to the sexual intercourse or not, or whether rape occurred or not. Third, and very importantly, the Sadaf Aziz judgment held that there was a need to amend medical legal protocols and different procedures across the criminal justice system to facilitate a victim of sexual violence, to ensure that the victim is not re-traumatized. And as we use the term care and caution, those were the words used by the Lahore High Court. Um, and that it is clearly explained to her what sort of medical procedures she will be having to undergo and what will be the consequence of those medical procedures. So there was a lot of focus on having the victim understand the process of the law and taking her full informed consent. Now, whilst it was very interesting that while this case was going on, there was also a lot of movement at the federal level to amend the laws regulating rape. So there were two ordinances passed in 2020 and thereafter promulgated as acts in 2021. Um, in the eventual act that was passed, the position taken in the Sadaf Aziz judgment was reinforced, and it was categorically stated that two-finger testing or virginity testing has no probative value and is prohibited, will not be conducted. So we have that one example of how a judgment then also translated and was reflected in legislation passed at the federal level. Um, but and at the same time, other mechanisms were put into place. There was, a provision made for the establishment of an anti-rape crisis cell. There was provision made for special courts that would hear rape cases and cases pertaining to sexual violence, and there will be particular protections accorded to the victim. Valerie referred to some of those protections that are used in the juvenile justice context, such as not having the victim confront the accused, using having in-camera trials, using video links, etc. So that's all great. But when it comes to implementation, we have not fared very well. In fact, the amendments that were brought in 2016 were up till 2019, 2020 not being implemented when we saw another phase of reform in the rape law. There was a study conducted in Lodhra where much after the 2016 Act was promulgated, which reported that in half of the cases, no medical legal examination was conducted because there were no medical legal officers in the districts, that there was substantial delay in even registering the FIR. DNA swabs were hardly ever taken. So, you raise a very important question that we have all these principles and judicial pronouncements and laws being enacted and promulgated. But when it comes to implementation, we are far behind. We lack commitment. There was reference made to political will, and obviously there will have to be a great amount of political will to, let's say, implement the sort of mechanisms that the 2021 Acts has provided for. But at the same time, I think the justice sector should look internally as well. There is a lot of requirement and need for training of judicial officers, of police officers, of medical legal officers in what we may call a new narrative that the judiciary and the legislature is trying to build a new understanding of GBV, of new understanding of presumptions regarding women's behavior or control of their bodies, or presumptions regarding their character. Now, coming back to the Sadaf Aziz judgment, just a few weeks ago, I checked up with somebody I knew in the primary and secondary health department here in Punjab, and I asked if the suggestions or the directions rather made by the Lahore High Court in the Sadaf Aziz judgment had been implemented or not. And the response I got was, yes, we changed the guidelines that were existing, because those guidelines made reference to finger testing and bimanual examination, digital examination, which are other words for two-finger testing, but they haven't been notified. So even if there's a little bit of movement, it's not going all the way. I believe like eventually stakeholders must be brought together, and the change will have to be driven by the executive, a bit of push and shove by the judiciary also. It has to be a collective effort, because we're trying to change thinking and trying to implement change across the criminal justice system. I think the GBV court in Lahore and some of us may have visited it, is one example of how change has come about on the ground, and we have seen a positive way in which directions given by the High Court is a practice note which regulates the procedure or sort of advises judges how to conduct proceedings in the GBV court, how those are being followed, and studies on the effects or the sort of the responses that litigants have to the GBV court are generally positive. They feel much safer. Parents feel safer bringing their children in. There is, a greater sense of security in that courtroom. So that's one example of how stakeholders coming together have, brought about positive change, which is impacting people's lives on the ground. So we have the framework now in place with pronouncements of the superior courts, and with at least as a parent from legislation, the will to sort of move forward with this change. But we must allocate enough resources and enough thinking and commitment to bringing these changes into effect.
Right. Thank you so much, Sahar. And Sahar talks about stakeholders, which is extremely important. And Ma'am Farkhanda, my next question, of course, will be to you, because we have seen that the role of national human rights institutions in the protection of human rights, especially when we're talking about gender justice and child justice, is integral. When we're talking about implementation or a lack thereof of the laws that Pakistan has promulgated, how do you think the NCHR's role can be leveraged in helping the state or supporting the state in implementation?
There are two things that we need to consider. The National Commission for Human Rights can be instrumental in urging the implementation of especially the gender non-discriminatory laws that have been promulgated. There can be a campaign carried by, because they have their presence in the entire country, including all provinces and Islamabad, there need to be a designed campaign to reach out to the lowest strata of society, so that this is on the one hand, we need to reach them, make them aware about these laws. The second is to conduct sessions with judicial officers and the lawyers, people from lower judiciary to higher judiciary, if they don't feel any ego involved in this kind of learning. And then these sessions may be conducted to make them aware how important it is to implement the laws that are there. Because unless and until an implementation mechanism is designed, and that takes a long time, that can be an intervention on the one hand, and on the second, as a second thing that the commission or any right-based body can do, Commission on the Status of Women can also be instrumental. That rather, if they both join hands and then they carry out some interaction with the judiciary, the judicial officers, and the prosecutors, there can be some sort of awareness raised with them in the form of trainings, maybe, or in the form of focus group discussions. But there should be some mechanism to design these campaigns so that they can be effective. They may not just be another campaign in that dimension. It needs to be effective to the extent that it reaches the lowest of the low and the higher of the higher. But all these four stakeholders need to be intact. I just want to add, away from this question, one small thing. When Sahar and Valerie speaks about the gender-based violence, I would like to reiterate here that gender-based violence has been very, very wrongly perceived and conceptualized in our perspective as a social system. Now, what we think is, or rather what a common person thinks is, that gender violence is committed only when there is some physical torture committed and inflicted. In the perspective of jails that I have visited through, a new form of gender violence has emerged, which I would like to bring to the notice of Honorable Judiciary. Women are being used as carriers of drug. And not only women, it's an issue that relates to women and children both, because rights of both those communities are being usurped. Women with small children between the age of 1 to 2 years are used to carry drugs across the provinces. And when they are intercepted, they are brought to the jail for trials. It's not only that violence is being conducted on those women for being carriers, it's the right of the child also who's being brought to an environment which is against the spirit of raising a child. So this issue needs to be taken up as an aspect when we are discussing the gender-based violence in future. And I would request all the honorable stakeholders here, when introduction was being made, I heard there was somebody from the narcotics department as well. They need to take care of this issue, and they need to take cognizance of this fact that why are women with small children being used as drug carriers, and this aspect of violence should also be now part of our main discourse that we discuss.
Exactly. Thank you so much. And I just have one last question before I open the floor to further questions from the audience. Valerie, I want to discuss, so we've talked about implementation of laws, we've talked about how stakeholders can support this implementation, but with regards to child justice, how do you think we can improve implementation specifically in terms of institutionalizing age determination protocols as well?
So, well, first of all, the first level of institutionalization is the fact of putting it into the legal framework per se, number one. So that's how you start institutionalization. Then all the judicial academies have included child justice in their program, and I believe that many police academies are also doing it. And there is, based on the Supreme Court of Pakistan decision related to legal education, an increased effort and a pilot specific effort from the Lahore Bar Association to also start, giving a compulsory course before being licensed as the lawyer that includes child justice. But I think what we need to do, number one, ideally, we would need to go and talk to the National Judicial Policy Making Committee again and tell them, listen, because they have been receiving those official reports since 2019 of those child court assessments, and basically even the NJPMC decisions highlight that there is now evidence of what works and what needs to be improved. And I think what we need, and today is only the beginning, is first to organize badly, a national conference on child justice in Pakistan. The reason I'm telling you that is because during the World Congress on Justice with Children, which took place in November 21, Pakistan was represented for the first time in that Congress. Honorable Justice Said Mansoor Ali Shah was the speaker. And frankly speaking, the world was, appalled by the success stories that Pakistan had to show. So we have example of good practices that need additional work and need additional support. We have evidence. We need to bring, that's what Sarah was saying yesterday, that's what many of the panelists have been saying, I'm not inventing anything. We need to take that evidence on board. Bring all the stakeholders, and in that case, justice actors together, and design an action plan with very clear results criteria, monitoring criteria. Year one, this is what we do, where, who's going to do what. Roles, responsibilities, resources, methodology, and then performance indicators. We look where we are, we go through, I know it's a very developmental framework, that's where I come from, I'm sorry, but this is tangible and it's working. And I come from a context, I really want to point it out, I'm redundant, but it's important. I created with Pakistani activists an organization in 2006, which is called Acid Survivors Foundation Pakistan, to end acid violence in the country. Faranda Appa was one of the pioneers and the supporters. when we started this action, some foreigners were looking at us. I think I had a presentation to do in front of some students in a university or whatever. And, I'm like Sarah, right? We are positive. We always see the glass more than almost full, all right? And so I told in front of the students, and you'll see, in a few years, we will be able to show the world what Pakistan can do. And I remember this foreign ambassador looking at me like, come on, calm down. What the hell are you talking about, right? Well, I wish this guy would be there today, okay? But we are today, the 20th of November 2022. And since 2014, Pakistan has decreased acid violence by 85%. This is a world record, okay? I mean it, I stand by it. This is the world record in reducing GBV. The only other record which came after this one is in Africa related to female genital mutilation. So what I'm saying is that if we have a plan, and we do not have a problem in Pakistan for the political and institutional buying to make it happen. People are ready. They just need to be guided on the how, and they need to organize and structure the synergies. Okay, and they need technical expertise. But if we decide as Pakistanis to do it together, I'm saying that to you today, the 20th of November 2022, we're going to show the world, we can show the world how we can transform child justice in this country. We need a chance and support. That's what I can say. Thank you.
On this very hopeful note, I will take questions now. Yes, I think we should start with Sahara.
I just wanted to ask the panel very quickly. When we talk about gender justice and we talk about child rights, and a lot of conversation has taken place about what's happening in prisons, what is the view of the panelists on using decriminalization of poverty, which basically means striking off the colonial era laws that, largely lead to children and women and the marginalized folk who might be mentally ill or with psychosocial disabilities ending up in prison. Is that something, I just want to know what the panelists think about that as a strategy to, accord better rights to these marginalized people and also empty our jails. And is that something perhaps with the superior judiciary here, we can explain that concept?
Yeah, of course.
Sarah, it's a very valid point brought forward by you. As a student of law, when I used to read some law from 1835 still being, how has the world changed? And if you keep on applying the same laws, so one of the roles of the commission is to suggest so many changes in the legislative process. So we need to look into those laws, and then we need to revise them to bring them in accordance with the modern times that we are living through. But who has the major? You see, what are the judicial academies supposed to? I think most of the judicial academies, with all due apologies to the staff of the judicial academies, they're not performing according to. Otherwise, you see, when we are talking about the non-implementation of things, because of the ignorance of the tripartite group that we are talking of, had they played their vital role, been proactive in bringing up all those things. So what I think is that, yes, there has to be a thorough cleansing of the legislation that we already have. It should never date back to 1970. It shouldn't be beyond that. The oldest legislation that we should be following should be from 70 to 73 and not later than that. Because earlier than that, the system that we were living in were for this to subdue one of your conquered nations. We were the ruled and they were the rulers. But now, since times have changed, the colonial rule has ended up more than 3/4 of a century. The laws which were promulgated in those times, beginning from the Thana, you see, Thana culture was created. I was once talking to Helena, a very old-time friend of mine, since she too hails from Quetta. I said, "Ke, why do policemen shout and terrorize people when they are going to arrest them? There can be an honorable way of carrying people to the van. How do they pull them, push them, kick them, and all?" She said, let me tell you the truth. This is how we are trained in the academies that we go through. You see, the sylvi of all those police training academies need to be changed, because those times they were taught to control people by force, and the basic purpose of police is to police ka hai farz, madad aapki. You see, we should look upon police officers as saviors. Otherwise, I feel most of our population is scared by the presence of a police officer. So, going back to those academies who are training the police and other also, we need to have a thorough review of the legislation that we have, and some new legislation should emerge according to the needs of the time and according to the needs of an independent sovereign state that we live in.
Right. Thank you, Farhanda Appa. We have one time for, yes, 2 more questions.
Hi, thank you so much for this enlightening talk. My question basically is, and this is for just to give you a background, a context. Pakistan's had some progressive legislation that has come up with the Child Marriages Restraint Act, which obviously goes back to 1929, but there's been new ones, which is, which tends to raise the age to 18. However, one thing that we've seen, and this is also true of the Transgender Act as well, is that there are medieval structures in our legal system which stand in the way of progress and reform. And then there's the orthodox opinion. Now, how has that affected your work, the panelists? And how do we get around the medieval structures within our constitution, within our legal system, and have reform and progress, actual reform and progress?
Right. Thank you. I think we'll take brief comments from both the panelists.
So, so if you talk about child marriage, we just first need to acknowledge that this is a provincial legislation and that is an unequal one. The minimum age of child marriage in Pakistan is 16 for girls and 18 for boys, except in Sindh, where it's 18 for both. I personally do not think that problem with regard to that law resides in the constitution. I think it resides in a distorted interpretation of Islamic jurisprudence, which is increasingly being addressed. The latest federal Sharia court judgment on minimum age clears those confusions, stating that there is absolutely no impediment in Islam to set up a minimum age. We are having, and I'm a member of the group which is currently working on the legislation. We have on one hand, and you will see that in any country, right? A conservative, regressive interpretation of a certain religious framework. However, there is no problem in protecting children from abuse and violence as per Islamic guidance, right? Contrary to what some people are trying to tell us, and again, this has been clarified by the Apex Court, the fact of setting 18 as a minimum age of marriage is not a problem. Now, what is problematic, and it's probably more a matter of anthropological framework and customary practices, and also socioeconomic inequalities that are exacerbated by what you call that, crisis, whether security crisis or climate change crisis. All this needs to be taken into consideration, and also the fact that in the context of Pakistan, away from wedlock, there is no concept of sexuality. So practically speaking, the question that we are facing right now is, and we also need to understand that child marriage is not always a form of gender-based violence. And just to explain to you, I mean, in a tangible manner, what do you do when you, for example, have 2 teenagers, all right, who decide to get married? Do you declare the wedding or the union null and void? And by doing that, are you actually serving the best interest of the child? not only in line with our constitution, but also as per international safeguarding standards. And I do not have the answers. I only have humble opinions. I think there is currently a dialogue with the religious leaders, and enlightened, informed religious leaders. That's very important. Um, and also legal experts, as well as child protection experts, who are currently trying to see how we could, on one hand, ensure that these harmful practices, and when I'm using that term, I'm certainly referring to the joint declaration of the CEDAW and UNCRC committee, but I am also quoting the fatwa of Al-Azhar University and several, the recent decision of Justice Babur Sattar, and again the Federal Sharia Court decision. So we need to find a way. It could be a clause of exception. There are several options that are currently being discussed. And it's a legislative exercise that needs to take into consideration how, in a certain cultural context, you can abide by the international safeguarding standards and protect children from abuse that are inherent to child marriage or who are intersecting with child marriage.
Right. One last very brief question. Some from here, please. Can we do 2, 3? Okay.
Very important and fruitful discussion for all the audience we had. The job of the judiciary, in my personal understanding, is to act as a whistleblower. And that's what we have been doing in a number of cases. Now, when everybody has listened to that whistle, now everybody has to act according to their own requirement and state and perspective. The Lahore High Court judgment has emphasized, which judgment has been accepted by everyone. Now, what to do next? There has to be some legislative reforms, and without that, it will be, I think, not a good idea that every institution of the state should start implementing the judgment directly, without having the legislative support. One. And number two, it was pointed out that we are being dealt with old colonial laws. Every law has a specific life, I think, except the God-made law, because that is universally applicable. If a man-made law has a specific life, we got to know when its life ends. And the best parameter is to get the feedback from the society. For example, gender-based violence, if we have started implementing a law, we should have definite parameters to ascertain whether the law has served the purpose or not. And I think this forum, JJP, Justice Project Pakistan, is a very important forum where we can have a regular sort of input, regular sort of monitoring that, okay, so many cases have been reported earlier and so many cases are reported after when the law was implemented. And this is the result we have. Do we have the lesser reporting of the gender-based violence cases, or it has increased? So based on that, I think we can further recommend the reforms in the law. And that is why I think we got to have, I will strongly request and suggest the GPP to have a permanent body which can review and recommend the implementation of those laws on which we are talking about. Thank you.
Thank you so much for the comment. We have one question from there.
Hello, everyone. My name is Sherkan Malik. I'm a human rights activist. I work on trans rights and FORB. Thank you for this eminent panel on elucidating these matters to us. I have a two-pronged question, so do bear with me. It's going to be short, though. On the trans law itself, we know there's a lot of controversy, but I'm going to talk about something intersectional in terms of child rights and gender justice. We talk about the rights of female child, the male child, but we don't talk about the trans child often enough. And the thing is, in Pakistan's law, there is no actual legal mention of trans children. Even in the Trans Act, there's no actual penalty or teeth, as they say, repercussions for abandoning a trans child. Often, the community is abandoned from age 13 to 15, from what I found in our data and our work with them on the ground level. So how do we combat that, and how can the state play a role in facilitating these trans children? And the second prong of this question is that within the community, the trans community itself, there are a lot of intra-community human traffickers who take a great advantage of these young, vulnerable children. They put them into prostitution, dancing, and so much more against their will. And how do we combat that, considering that FIA, whenever I've approached them, even in closed meetings, has clearly stated that trafficking within the state is not of concern to the FIA or its current policies, but rather trafficking that is cross-border. So trafficking that is exiting people out of the country for, heinous purposes. Thank you so much.
Valerie, I think you'd be best to answer this question.
My organization is Transgender Rights Consultants Pakistan, TRCP. Thank you.
So as per the Child Protection Framework, which is specific to Pakistan, and including the Trafficking in Person Act 2018 or the Juvenile Justice System Act, a child is a person under 18 years of age. When you refer also to a section of the PPC that defines sexual abuse, it's the same, 18 years of age. So regardless of that child being a boy, a girl, or a non-binary child, as per law, as per our constitution, that child is equally entitled to any fundamental right, including the right of being protected. Now, I agree with you that there is a problem in the transgender law, and and especially the fact that the guru may be appointed as the legal guardian. I have a strong problem with that from a legal perspective. It's the first time I'm saying it publicly, because I agree with you. In my view, if there is anything to change in that law, this is it, not the rest, okay? Because this institutionalized commercial and sexual exploitation of children, and without doing it, that was not the intent of the legislator when they did that. They just didn't understand it. I think what we need to do, so from our perspective, it's not a legal issue. And when justice actors are trained, whether it is police or judges or the lawyers, they are trained about, remember, one of the fundamental principles of this child justice or gender justice. When we say gender justice, it's because we include all genders, and child justice is limited to children in conflict with the law. But basically, justice with children means you're talking about gender justice as well as child justice, right? So as all the justice actors are legally bound to treat and protect non-binary children the same way. Now, the problem is about sensitization, community engagement on realizing what gender variance is, supporting those children. It's also an institutional issue. Which school and which teachers, for example, is being legally bound and is being held accountable to welcoming children? What are we teaching in the curriculum to children, regardless of this gender variance? So there is an awareness issue, a systemic issue to be addressed through education purposes. And also, when you have under the law child protection institutes, in my view, and as per the law, you don't need to have a separate institute for children who are non-binary. And again, when you talk about child protection framework, let's be very clear. It's institutionalization is always the last recourse, and it should be for the shorter period, including for children who need to be protected. So when you do that, you need to have child protection mechanism and systems of alternative care and referral system that are developed, monitored, designed, and applied equally for children who also are not non-binary. It's going to take time, because anywhere in the world, unfortunately, this is something which is usually, first of all, not understood, misunderstood, and which terrifies our duty bearers, because it challenges what we've been molded with within a binary framework, basically.
Thank you so much. And on this note, I will end the panel discussion. Thank you so much to the panelists.
Oh, sorry, I forgot something important. The trafficking thing, the FIA is absolutely right. So we need to hold the police accountable for trafficking. Yeah.
Thank you so much, Valerie.
One last word is that when we take CRC into consideration, the very first right that it gives is non-discrimination,
Yeah,
right? So whether it's a girl or a boy or a trans child, they all need to be treated as child and nothing beyond that.
Thank you so much, and thank you to the panelists and, of course, the audience for their very important questions. And I hope you enjoyed the discussion as much as I did. Thank you very much.
Thank you. So I need your help.
इधर से आ जाओ.
Okay, good.
Thank you. Mm. Thank you so much.
Hello. So I cannot contain my excitement because the Senate has just passed the torture and custodial death bill, and after assent from the president, it will become a law and act of the parliament. And yeah, this is just an amazing day. Also, I would like to remind everyone that when you're posting about this conference, please do use our hashtag. It's on the table as well. And yeah, we're trending as well on Twitter. So yeah. Also, health break.